think we're ready to start. Hello, I'm Mikan Shelton. I'm a mediator with ADR Services, and I specialize in employment disputes. And I'm also the programs chair for the Beverly Hills Bar Association's Employment Law section. And today I'm absolutely delighted to introduce our speaker, Rachel Green. Rachel Green is a senior associate at Katz Kumin, where they represent employees in workplace discrimination, retaliation, and whistleblower matters, as well as executives navigating compensation and severance negotiations. Rachel has litigated in federal and state court and before the EEOC and OSHA. Rachel clerked for the Honorable David F. Hamilton of the Seventh Circuit Court of Appeals. They serve on the board of the Metropolitan Washington Employment Lawyers Association and on its DC Legislative Committee. I'm so excited to now hand it over to Rachel. Over to you.
Thanks so much, Mikan, and hi, everybody. Good morning from the East Coast. My name is Rachel Green, and I work at Katz Kumin. We do have a San Francisco office as well as DC and New York. And today we are going to do a deep dive into the nuts and bolts of non-compete law in California. As many of you might know, if you're following this space, the landscape has shifted significantly even in the past year or two in California and across the country. So what I want to do is, time permitting, I'd like to go over 5 main areas. First, I would like to talk about California's statutory framework and the key cases that define it. Second, I want to take a close look at the First Circuit's draft King's decision. So we'll get into that. Generated a lot of headlines. I'm sure many of you have heard about it. Third, I'm going to talk about the newest California legislation, including the trap ban. Fourth, I'm going to briefly touch on the federal landscape because I think it's important for folks in this space to be aware of what's going on, including the demise of the FTC rule. And then finally, we'll briefly zoom out and take a look at what other states are doing and what the emerging patchwork is looking like especially for multi-state employers and employees, because that is happening more and more in this post-COVID remote work era. So let's jump in. Next slide. Thank you. So before we get into California specifically, let's frame the national picture. So roughly 30 million American workers are currently subject to a non-compete agreement. That's about 1 in 5 working Americans. And the research on this is fairly consistent. Non-competes suppress wages, hamper innovation, and block entrepreneurs from starting new businesses. And these aren't just theoretical concerns. The data really does back it up across multiple studies and industries. There's a lot of science on this. Currently, there are 6 states, including California, with total bans. California has been at the forefront since 1872, well over 150 years. And what we're seeing now is that California's approach is continuing to expand. So with that national backdrop, let's turn to California. Next slide. It is no coincidence that California has seen more than a century of enhanced economic development, wage growth, innovation, entrepreneurship, competition in the years following its enactment of the broad non-compete ban in 1872. However, California's approach is not the norm, and most states actually have permitted non-competes with few, if any, restrictions until the past 20 years or so, and some in the last 12 years. In 2014, there was this big Jimmy John's case that's frequently thought of as this case that spurred state legislation across the country, banning and restricting non-competes, because a lot of folks felt that it was almost incomprehensible to imagine the necessity of a non-compete limiting folks from working at a Subway chain if they had previously worked at a Jimmy John's, for example. So really a lot of the legislation that we've seen across the country and in individual states has happened in the last decade to 20 years. But California is very much an outlier for having this 150-year non-compete ban. So the very beginning of this California section, we're going to start about the statutory framework and the key cases, and I want to talk about the statute itself. Next slide. Thank you. So California, which again has effectively banned non-competes for over 150 years, it has the broadest non-compete. Some states have been increasing the breadth of their bans, but California remains the broadest. Its statute prohibits agreements that restrain California employees from engaging in, quote, a lawful profession, trade, or business of any kind, and it voids the agreement. There are very limited exceptions, mostly in the context of sale of a business. We'll talk about those in a minute. But even if one of the narrow exceptions applies, the scope of the restrictive agreement must still be reasonable, both in scope and in duration, geographic scope, and in duration. And the language itself is sweeping. Again, it says every contract by which anyone is restrained from engaging in a lawful profession, trade, or business of any kind is to that extent void. That's it. There's no reasonableness analysis. There's no balancing test. There's no consideration of whether the restraint is narrow or broad. If a contract restrains someone from engaging in a lawful business, it's void. And this is the foundation for California's strong public policy favoring employee mobility. And it also critically applies to all workers, regardless of their industry, of their role, of their compensation level. It doesn't matter if it's a junior employee or a C-suite executive, the prohibition is the same. And that's not the case in many other states, which we'll touch on towards the end. So there was a 2024 amendment, which we'll talk about in a minute, and it was likely passed in response to some California employers' attempts to continue to force employees to sign unenforceable non-competes. So this 2024 amendment also states that an employer that either enters into a contract with a void non-compete agreement or attempts to enforce a void agreement, quote, commits a civil violation. And this 2024 amendment also provides that employees, former employees, prospective employees, any of those three categories may bring private civil actions for injunctive relief or actual damages, and might be entitled to recover attorney's fees and costs. In other words, the new law, this 2024 amendment, has some teeth. Employees can sue their employers for damages if the employer tries to enforce a void non-compete. So again, that probably came about because some employers, even though there is this 150-year ban, were attempting to enforce non-competes at that time. So we're going to talk a little bit about some of the case law that has shaped interpretation and understanding of this section 616600. Next slide. All right, so Edwards versus Arthur Andersen LLP. If you aren't familiar with it, it's worth taking a look. I have the site in the bottom of the page in case you want to look that up on your internet browser. So for many years, there was a question, it was an open question about whether a narrowly tailored non-compete might still survive. It's very narrow. And the Ninth Circuit outside of California had allowed what it called this narrow restraint exception. And the idea being that if a non-compete was reasonable and limited in scope, it could be enforceable. And that's common in many circuits across the country. So in 2008, the California Supreme Court unanimously rejected that idea. It unanimously rejected this narrow restraint exception. So even narrowly tailored non-competes are void. And the court's reasoning was straightforward. It basically went through, I have its major reasoning here in this gray box on the slide, but essentially section 16600 is unambiguous. If a contract restrains someone from engaging in a lawful business, it's void, period. The only exceptions are the ones specifically enumerated by the legislature. And the court pointed out that if the legislature had intended the statute to apply only to unreasonable restraints, it could have said so, and it didn't. So the case eliminated any remaining argument that partial or limited non-competes could survive in California and really just closed that option completely. So that's sort of a pivotal case as far as making sure that folks understand the real scope and the extent of the non-compete ban in California. Next slide. Now, I said the only exceptions are those enumerated by the legislature. So what are those? They're all narrow and, they have separate sections within the code. So first, section 16601 covers the sale of a business. If you sell your business, the buyer can require you to agree not to compete, but only within a limited geographic scope and only for a limited time. Pretty narrow exception. The second one is section 16602, which addresses dissolution of a partnership. Somewhat similar, partners can agree not to compete within a geographic area of the partnership's business upon dissolution. Pretty straightforward. And then third, dissolution from an LLC, section 16602.5. Similar, they can agree not to compete within a specific geographic limitation. And that's it. There's no exception for executives. There's no exception for employees with access to, secretive information at a company. There's no exception for highly compensated workers. If you're not selling a business, if you're not leaving a partnership, if you're not leaving an LLC, the non-compete is void. So again, the fact that the legislature enumerated these exceptions, courts, especially in the Edwards case, have found to be demonstrative of the legislature's intent to make the California non-compete ban quite broad. Next slide, please. So this is this 2024 amendment that we talked about a little bit earlier. In 2023, the legislature went further with SB 699. It added a new section, and we're going to dive deep into this new language in a minute when we get to the DraftKings case. But it added this new section to the Business and Professions Code and addressed a specific problem out of state non-competes. And this certainly came about in the aftermath of the COVID pandemic when many, many, many workers in California remained employed by California employers, but moved out of state or remained in state, but wanted to work for other employers. So a lot of folks might have been living in Texas or in Tennessee or in Oklahoma and wanted to live in California and moved there, but were subject to an out-of-state non-compete while they lived there. So under this new law, non-competes are void, quote, regardless of where and when the contract was signed. So it doesn't matter if you signed the contract in New York, Massachusetts, Texas. If California law applies, the non-compete is void. It also, again, as discussed previously, prohibits employers from even attempting to enforce a void non-compete. So the act of trying to enforce it also violates the law. We already talked about the private right of action for employees. We already talked about the remedies available. And notably, there is no counterpart fee shifting provision for prevailing employers, which makes the risk calculus very favorable for employees that might bring these claims. And again, it really just demonstrates California legislature's intent to protect workers from non-competes, including out of state. But we're going to touch back on this, so we're not done. Next slide. There was another amendment that the legislature passed in the 2023 session that was also effective in 2024. This is AB 1076. It added section 16600.1, and it's a codification of Edwards, the case that we discussed earlier. It declares it unlawful, not just void, but unlawful to include a non-compete in any employment contract. It also clarifies that section 16600 and the sections that follow is not limited to contracts where the person being restrained is a party. So this is a direct shot at no rehire provisions and similar arrangements between companies that have the effect of restraining workers. AB 1076 also imposed a notice obligation on employers. And so by February 14th, 2024, mind you, not very much time, only about 6 weeks of time after the law went into effect in January 2024. So by February 14th, employers were required to send a written notice to all current employees who had a void non-compete in their agreements and to former employees who were employed after January 1, 2022. That notice specifically had to state that the non-compete clause is void. And failure to notify constituted unfair competition under Section 17200 with enumerated penalties of up to $2,500 per violation. So if any of you folks watching this are advising employers, this is a compliance step that I'm sure you're aware of. And I'm sure you've worked with your clients to make sure that this was completed and um, any new clients you have, I'm sure you are aware of this. Okay, next slide, please. Scope questions. So this slide raises some of the gray area questions that still come up. I mean, I think what we've touched on is that the statute is quite clear and quite broad and quite firm. And the legislature has only sought to expand protections for employees. However, there are some gray areas. First, non-solicitation provisions. Neither SB 699 nor AB 1076 explicitly address non-solicitation agreements. There was a case in 2018, and I have the case site in the bottom of the screen here. It says AMN Healthcare v. IA Healthcare. This extended Section 16600 to the employee non-solicitation provisions, at least in the relevant agreement. And multiple courts have followed that reasoning. The practical takeaway is that employee non-solicits are likely unenforceable, but I think there's still probably room for argument there. The statute does not say so in express terms, and I I do not believe any court has explicitly stated that. It has been more of a fact-specific argument, and so folks on either side probably still have arguments to be made, but there is a definite shift and a definite general agreement that courts have followed AMN healthcare. So practically speaking, non-solicitations are on really weak ground in California. And that might be the next area that we see. Second gray area is in-term restrictive covenants. So these are covenants that restrict during the employment relationship, and these do remain permissible. There was a 2020 case, Technolite v. MCOD. Again, the site is in the bottom of the page, where the court upheld restrictions that applied during the employment relationship. And interestingly, the court did draw a very clear line. It said that post-employment restraints are void, but during employment restraints are permissible. So you can't just compete while you're employed by your employer. And I think that makes sense. There's somewhat of a duty of loyalty assumption that's being applied there. Okay, the third gray area I want to talk about is trade secret protections. A lot of employers are understandably nervous about protecting their trade secrets, and that underlies many employers' desires to have non-competes in the first place. Trade secret protections do remain fully enforceable independent of Section 16600. You can still protect your trade secrets through NDAs, through the California Uniform Trade Secrets Act and related remedies. The non-compete does not touch those protections. They're completely separate. So I just want to flag that. Okay, we're going to move on to DraftKings. Next slide, please. So let's shift to this case. It generated a lot of attention when it came down almost 2 years ago. This is DraftKings versus Hermalin out of the First Circuit. Next slide, please. So let's go over the facts. Hermalin was a senior vice president at DraftKings, which is headquartered in Massachusetts. He worked primarily from New Jersey and New York, not in California. And he signed a non-compete with a Massachusetts choice of law clause. Then he decided to leave and join a rival called Fanatics in a California-based role. Just a couple days before he resigned, he established California residency. So he got a California driver's license, he registered to vote, he leased an apartment, he moved. And the timing ultimately raised questions about whether this was a genuine relocation or a strategic maneuver to get under the umbrella of this new non-compete ban, or this expanded non-compete ban, my apologies, with the 2024 amendment that we discussed, saying that even out-of-state non-competes are void under California law. And that's the setup. So there's this employee who had not previously worked in California who tried to invoke California's protections by moving there just before resigning. Next slide, please. So DraftKings sued, and they sued in Massachusetts federal court because they wanted Massachusetts law to apply, and there was a choice of law provision in the contract. And the district court did apply Massachusetts law and ultimately found the non-compete enforceable, the Massachusetts non-compete, in spite of Hermalin's arguments about the new California expanded law. And the court issued a preliminary injunction and barred Hermalyn from competing in the United States for 1 year. And then Hermalyn appealed and the First Circuit affirmed. And that's what kind of broke a lot of news. The First Circuit applied Massachusetts choice of law framework, which is called the functional approach, and ultimately found that Hermalyn failed to show that California's interest was, quote, materially greater than Massachusetts' interest in whether or not to enforce the non-compete. The court looked at some of the relevant factors we discussed. It looked at where, his current California residence. It looked at the fact that the breach technically occurred in California because he started working for the competitor from there. But ultimately, the court concluded that Massachusetts had the stronger case and that its interests were materially greater. The harms that DraftKings suffered were felt primarily in Massachusetts. There was the Massachusetts choice of law clause, and Hermalyn had primarily lived and worked in Massachusetts during the employment relationship with DraftKings. And the court put it succinctly, Hermalyn just failed to show that California's public policy eclipses the parties' clear and unambiguous agreement to apply Massachusetts law. And so it applied Massachusetts law. Next slide, please. In case any of you are plaintiff side or employee side folks, I wanted to just walk through some of the key reasoning because as a plaintiff's attorney, I do work at a plaintiff's law firm, always trying to think about ways to distinguish a case like this. So the court distinguished a key case called Oxford Global Resources versus Hernandez. This is a 2018 Massachusetts Supreme Judicial Court decision, and I have the citation in the bottom there. In Oxford, the employee had lived and worked exclusively in California. So that's a big critical factual distinction. Hermalyn did not work for DraftKings in California until a couple days before his resignation. So that's a distinction that I think is really key. Second, the court pointed to the Massachusetts Non-Competition Agreement Act. And this was enacted in 2018. So the California non-compete, again, 1872. The court called this 2018 Massachusetts Non-Competition Act a paradigm shift in Massachusetts law, reflecting what it called a carefully considered legislative balance. And in enacting this law, the court found that Massachusetts and California were co-equal sovereigns over the non-competes that should affect employees in their respective states. And Massachusetts, the court concluded, had its own legitimate interest in regulating non-competes, especially those that had been signed in contracts that chose to apply Massachusetts law by their own terms. And so if you have any of those, if there's a state that doesn't have a non-compete ban, for example, perhaps this factor might weigh in an employee's favor in a way that it did not for Hermalyn. Similarly, if there was no choice of law provision, or if the choice of law provision was vague, or open for interpretation, those might also be factors that weigh in favor of the employee. Third reasoning the court applied is that California legislature had conceded that its laws, and it did, conceded that its laws cannot dictate to courts outside of its jurisdiction. So that was another factor that the court considered. And finally, the court refused to carve out California from the injunction, noting that the California does outlaw online sports betting, so Hermalyn would inevitably have to be interacting with clients outside of California. And the court also found that just a carve out would undercut the injunction's effectiveness. I mean, what would be the point of granting the injunction in favor of DraftKings if the employee who had breached the agreement by working for a competitor in California would still be able to do so? Okay, a little bit more. Next slide, please. Just to summarize how to distinguish Hermalyn. If you have an employee who genuinely lives and works in California, that would mirror Oxford. That would be a very strong distinction. Litigating in a California forum would obviously be more helpful than in an out-of-state forum. The California choice of law rules, having those apply would be excellent. Labor Code Section 925, if you're not familiar with that, prohibits employers from requiring employees who primarily reside and work in California to agree to out-of-state forum selection or choice of law clauses as conditions of employment. If you're not familiar with that, check it out. Number 3, if the employee's work is directed at California markets, and if the competitive harm would be felt in California, that definitely strengthens the argument. Fourth, if the employer actually approved or initiated the California transfer rather than, in the case of Herm Allen, it was the employee initiated transfer. There's no inference of pretextual relocation. And then fifth, the duration and authenticity of the California connection obviously matters, as we learned in this case. Definitely helps to prevent any successful argument of a sham residency versus a genuine one. All right, next slide. So the key takeaway, California's non-compete ban cannot be used as an escape hatch by employees that lack a genuine California employment nexus. But it does not hold that out-of-state non-competes are categorically unenforceable against California workers, or categorically enforceable against California workers. And I think that's key. This case is about the limits of California's reach. It's not a reversal of its protections. So employees who genuinely live and work in California remain protected by out-of-state non-compete bans, is my read of the case. And I think that we're going to just see ongoing litigation in this space, challenging the boundaries of application of DraftKings and its implications for California law. Okay, let's move on to some of the new legislation so that we're continuing to get up to speed. So there are developments from 2025 and 2026 that continue to expand what qualifies as a restraint of trade in California. Okay. Thank you. Okay. AB 692. This is the stay or pay trap ban effective January of this year. So AB 692 is a big deal. It prohibits most stay or pay provisions. And if any of you are not familiar with that, they're sometimes referred to as training repayment agreement provisions or traps. There are a lot of other similar phrases, but this is generally the category. And the concept is that an employee needs to complete some sort of training. And after completing it, if they leave before a certain period of time has passed, some employers contractually require the employee to pay back some specified or unspecified amount of money for that training if they leave. So stay or pay, training repayment agreement provisions, traps. So the statute under AB 692 amendment now adds a whole new section, 16608, to the Business and Professions Code. And the placement is deliberate. They could have added a separate chapter, added it elsewhere, but adding it to this particular chapter, the legislature is treating traps as a species of restraint of trade. And what the statute does is it voids contract terms that require workers to repay debts, penalties, fees, or costs upon separation. The underlying theory is this, functional equivalence. Traps have the same result as non-competes, just through financial penalties instead of contractual prohibitions. And economic coercion is essentially being treated as a legal restraint, creating a legal restraint. Instead of saying you can't leave, the employee says if you leave, you owe us $50,000. And so that economic coercion creates a legal restraint on the employee's mobility, even without an explicit non-compete. That's the theory behind it. Next slide, please. Like many broad prohibition, there are exceptions, and AB 692 lays these out. I'm going to cover them pretty quickly. The first covers bonuses and relocation expenses. These require a separate agreement. There must be prorated repayment over a maximum amount of 2 years, no interest charged. Attorney consultation notice is required. The employee must be able to opt into deferring. And the separation must be, the employee's choice or for misconduct in order for the bonus or relocation expense to be permitted. Many of us are aware of, bonus and relocation expenses at law firms. So a lot of us are familiar with these, and I think that the carve out is probably considered reasonable among most businesses and law firms. Okay, the second exception is for tuition. So tuition reimbursement can be contractually required for what's called a transferable credential, which means a credential not required for the employee's current job. So this has to be something that actually can be transferred to another job. It cannot be job specific to the extent that it's completely useless anywhere else. And this also requires, similar to the bonus and relocation exception, there must be a separate contract. There must be specified repayment amounts. And so it cannot just be an open-ended, cost to be determined sort of clause. It has to be specified. Also, it needs to be prorated repayment. There cannot be accelerated repayment required upon separation. And there is no requirement for repayment if the employee is terminated unless they are terminated for misconduct. So somewhat similar terms in order to make that fall under the exception. There are also, I'm going to skip over these a little bit faster. There are also exceptions for government loan repayment assistance programs, and if they're provided by the federal, state, or local government agency, for apprenticeship programs that are approved by the Division of Apprenticeship Standards, and also for leases, financing, or purchases of residential property. These exceptions are narrowly drawn, and any employer relying on them, should be wary to structure these arrangements carefully to fall within these safe harbors. Okay, next slide, please. On the enforcement side, it does create this new AB 692, does create a private right of action with significant teeth. Employees can recover $5,000 per worker or actual damages, whichever is greater. The statute also provides for injunctive relief, and the prevailing employees can recover attorney's fees. There's also potential PAGA exposure, the Private Attorney General Act, which deputizes employees to sue their employers on behalf of the state for labor code violations, something to be aware of on both sides, employer and employee side. A key point for practitioners, AB 692 and 16600 do create overlapping but distinct frameworks. A single provision could violate both sections of the statute, arguably, and so could create dual track exposure for employers. Obviously, this is brand new, hasn't been tested, but it's conceivable that both sections could be violated by a single provision. There are also some open questions that we're watching. What about retention bonuses that are offered mid-employment, not at the outset? How does this affect them? Remains to be seen. What about forfeiture of unvested equity? Could someone argue that that's a trap, or is that compensation design? Probably the latter, but it hasn't been tested yet. And how does this interact with IRC section 409A, deferred compensation rules? It's not clear. So these are probably going to be litigated in the coming years by, savvy employees who are testing the limits of this ongoing expansion of California protection for employees. Next slide. Another new amendment that I want to highlight for you is not in section 16600, but it does relate to non-compete. So this is SB 351, which is also now effective as of January of this year. This is a private equity physician non-compete ban. It voids non-competes for management of physician or dental practices after a private equity acquisition. So it's a really interestingly narrow amendment here, and it targets acquisitions by private equity groups or hedge funds. It also, so it voids a non-compete for the management of one of these practices after they're acquired. It also prohibits non-disparagement clauses on specific topics. And this piece is significant. It reflects a growing concern about the way that private equity ownership can create pressure to prioritize revenue over patient care. So I think the non-disparagement piece is sort of like a canary in a coal mine to a certain extent. At least it could be read that way. The statute also codifies corporate practice of medicine restrictions and just recognizes these unique and competitive dynamics of private equity acquired healthcare. It's a growing space, especially in California. And this bill is part of, as we'll talk in a little bit more, a broader national trend of healthcare specific non-compete reform, which we'll touch on later. It's one of the areas that just many, many, many states are introducing bills specific to the healthcare industry and making sure that physicians and dentists and sometimes veterinarians also are not prohibited by non-competes, or if they are, they're narrowly permitted non-competes. Okay, next slide, please. Before we move on to discussing the federal landscape, I want to just really briefly touch on this broader arc, so that we go through how California has just been expanding its definition of restraint. So again, in 1872, Section 16600, which it actually wasn't that section at the time. It was a different section, and it's been kind of recodified over the years. But as we now know it, Section 16600, the underlying language was codified in 1872 and explicitly banned non-competes. And Edwards then happened in 2008, as we discussed, and even narrow non-competes are still banned. 2018, AMN healthcare non-solicits likely going to be banned. They're certainly restricted, out of favor. 2024, SB 699 voided out-of-state non-competes, but DraftKings, as we discussed, makes that a little bit more challenging for it to be enforced as it may have been initially intended. 2024, AB 1076, even including a non-compete in a contract, is unlawful. And then AB 692 and the healthcare bill we just talked about are, both the expansion of this concern for restricting non-competes in healthcare settings and also banning traps and financial mechanisms similar to them. So that's what we have going on specifically in California, but I want to now turn with the remainder of our time to talk about the federal and other state contexts, because I think it's impossible to zoom into California without staying in touch with what is going on around the country, especially since I'm sure many employers and employees in California either work with or, are involved in multi-state contractual relationships. So it's important to be aware of what's going on. So let's go to the next slide, please. So we're going to shift to the federal landscape first. I'm going to talk about kind of going back in time to update you all, although I'm sure many of you have been staying in touch with this, on FTC rulemaking, the litigation that followed, and where enforcement stands today under the current administration. Next slide, please. Thank you. So in January of 2023, the FTC under the Biden administration announced a proposed rule that would have banned non-competes nationwide. It was extremely broad. And the public had submitted some 26,000 comments that almost entirely supported a non-compete ban. And in April of 2024, the FTC announced its final rule. I'm not sure how many of you are aware of the rulemaking process, but there's a proposed rule, there's an open notice and comment period, and then there's a final rule. And the FTC ban, again, it would have invalidated nearly all non-competes and new ones, existing and new, and it would have been retroactive, except for a couple of narrow exceptions. Very, very rare circumstances and exceptions would have been exempt. And this would have permitted workers to freely pursue nationwide new employment opportunities without fear of being sued by their former employers. It likely, given the research discussed at the outset of this presentation, likely would have led to increased wages and would have encouraged employees to, remain with their employers. It would have encouraged employees to search for higher wages elsewhere if they were not happy with what their current employer was providing them, because they wouldn't be so frightened of the implications of being pursued for a violation of a non-compete. Again, based on research that has remained consistent over the years, it also probably would have increased innovation and entrepreneurship, and workers would have been able to more freely bring their varied skills and experience to new roles with competing employers. And in case any of you, want to know some of the folks who were involved in this, it was then Chair Lena Khan, Commissioner Rebecca Kelly Slaughter, and Commissioner Alvaro Bedoya who voted in support of the rule. And now Commissioner Andrew Ferguson and Andrew Ferguson and Commissioner Melissa Holyoke were the two who dissented at the time. And this rule would have gone into effect in September of 2024. And it would have covered quite broadly, not only employees, but also independent contractors. So many of us who work in this space are aware that there are some states that only apply to employees and do not apply to independent contractors. Many do not apply to interns or to volunteers, but this one would have applied to all of them. So that is the rule as it was proposed 2 years ago. So next slide, please. The ban never went into effect, as we all know. The US Chamber of Commerce intervened in the first major legal challenge to the FTC rule, which was filed on May 9th, 2024, and it argued that the FTC did not have the authority to issue rules that define unlawful methods of competition. And if any of you had read the actual rule itself, the then chair, Lena Khan, had devoted probably dozens of pages of argument in the final rule demonstrating and providing legal authority for the FTC's ability to issue a rule that defines unlawful methods of competition based on the FTC's role in enforcing the FTCA. And however, the US Chamber of Commerce argued the opposite. And there is a Northern District of Texas case where the district court granted summary judgment in favor of the Chamber of Commerce. By doing so, it prohibited the FTC from enforcing the rule nationwide. The FTC then appealed to the Fifth Circuit Court of Appeals. This is all in 2024. And just as an aside, there is a parallel challenge in the Southern District of Florida, this Properties of the Villages versus the FTC. It involved a real estate brokerage that wanted to enjoin the FTC from enforcing its ban. And a similar result. The court also enjoined the FTC. Looming over all of this is the Supreme Court's decision in Loper-Bright, which, as we know, limits agency deference and makes administrative rulemaking even more unlikely going forward and even harder to succeed a challenge like this. Next slide, please. When President Trump took office for his second term in January 2025, the Fifth Circuit had yet to rule on the legality of the FTC non-compete ban on the appeal from the FTC's from the Northern District of Texas's decision in Ryan LLC. And President Trump selected Andrew Ferguson, a fellow Republican, to replace Chair Lena Khan, a Biden appointee, as chair. So Chair Ferguson, about a month into his new role in 2025, shared with Fox Business that the FTC under his leadership would not prioritize broad prescriptive regulations like that non-compete ban under former Chair Khan. But instead, he said the FTC was going to emphasize case-by-case enforcement of existing laws. Now, as we have seen over the past few years, this type of piecemeal enforcement is considerably slower, less efficient, and less effective than the ban that the FTC had enacted. And such an approach also ignores the very limited resources of the FTC, which at least at the time was comprised of only about 1,000 employees tasked with protecting customers from all different forms of unfair or deceptive or fraudulent business practices, and with promoting competition by preventing anti-competitive mergers or other practices nationwide, let alone just focusing on, non-compete piecemeal approach that now Chair Ferguson said he wanted the FTC to focus on. In March of 2025, a little over a year ago, the FTC under the Trump administration asked the Fifth Circuit for a 120-day pause on the FTC's appeal. It cited the changeovers in the administration. It cited the comments by the new chair about the FTC shifting priorities. And in July 2025, the FTC requested an additional extension to the pause, which was granted. And in September 2025, just ahead of that extended deadline, the FTC voted 3-1 to dismiss its appeal of the district court's grant of summary judgment that had prohibited the FTC from enforcing its rule. And if you're interested in the votes, it was Chair Ferguson along with Republican Commissioner Melissa Holyoke and a Trump appointee who had been sworn in April 2025, Commissioner Mark Meador. They voted to dismiss the appeal while the Democratic Commissioner Slaughter dissented, the only remaining Democratic commissioner. The bottom line, the rule is officially dead. There is no pathway to revival under the current administration. There is no chance, I would say, that they're interested in instituting a non-compete nationwide ban. And even if they were, Loper-Bright makes future rulemaking attempts even less viable than they were. Again, Loper-Bright had ruled, the Supreme Court and Loper-Bright had ruled that an agency's interpretation where the law is ambiguous is not entitled to deference. So that lack of agency deference is just devastating for the ability of an agency to institute a broad ban like this one. Okay, next slide, please. So what is the FTC doing? It is pursuing case-by-case enforcement under Section 5 of the FTC Act, which covers unfair methods of competition. In September 2025, under Chair Ferguson's leadership, the FTC held a public inquiry with a 60-day comment period asking the public about what they thought that the FTC should do. That's one thing that the FTC has done, is held that open public inquiry. They also did engage in an enforcement action against Gateway Services, which is a pet cremation company with about 1,800 employees that had been bound by non-competes. They've also followed that with one additional action. So there have been two enforcement actions involving a building services contractor with no rehire agreements. And then there was a non-compete workshop held in January 2026, which I attended. It was available online. Primarily, there was discussion with a lot of veterinarians and folks in the vet industry about the benefit of this sort of trend of expanded restriction on non-competes in the veterinarian business. But otherwise, it was very much focused on existing law and not expansions of law. The pace tells the story. There are just two enforcement actions under his leadership. And at least to my mind, that demonstrates some sort of an efficiency of this piecemeal approach compared to rulemaking. So if you are employee side or if you were hoping for a federal solution, this is not it. And California law remains the best in the country on this front. Next slide, please. On the legislative side, the Workforce Mobility Act has been reintroduced almost a year ago by a bipartisan group of senators. Senator Murphy from Connecticut, Senator Young from Indiana, Republican, Senator Kramer from North Dakota, and Senator Kane from Virginia. So a mix of Republicans and Democrats. This has been introduced multiple times, 2019, 2021, 2023. I'm sure it will be reintroduced again. It would institute a nationwide ban on non-competes with limited exceptions. It has been referred to committee, but the passage is almost certainly not going to happen in the current political climate. It does demonstrate, however, bipartisan interest in a federal solution. And it also just demonstrates continued and consistent interest every couple of years and recognition that this federal legislative void is driving state level activity. And with that, I will move in our remaining couple of minutes to talk about nationwide state developments. And I know we're focusing on California, and I think that we should, but I also think it is interesting and important for litigators and practitioners in California to be aware of what the nationwide state developments are. Again, because many, whether you're employee or employer side, many folks are multi-state, and I think that this is where things are really happening quickly. California is continuously expanding its restrictions, but other states are kind of all over the place, and there are a lot of trends here. And I will just make a brief plug. I do have a 50-state survey available on my firm's website where I go through and I have an Excel spreadsheet as of March this year with all pending legislation, all existing legislation in all 50 states, and a map as well if you're interested in seeing what's going on. I'm just going to kind of skip through it very quickly. All right. So 6 states have total or near total bans. These are California, Minnesota, Montana, North Dakota, Oklahoma, and Wyoming, and Washington State has enacted a near total ban that will go into effect in about a year. Again, California's remains the longest standing ban, and Minnesota's the most recent, other than Washington State's coming in soon. The trend is clear, though. States are moving toward broader prohibitions. instead of just raising the thresholds, which we'll talk about in a minute. We are seeing a shift in the legislative approach, and states are increasingly moving towards total bans rather than, some sort of piecemeal approach. Next slide, please. One of the most common types of restrictions on non-competes at the state level is what I and many others have called a wage threshold non-compete. So you tie the threshold to average wages, either in the nation, in the state, in the county, some other metric in federal law. Sometimes they just put a number and they say will increase by a certain amount every year. And so practitioners who are looking to see whether or not an employee's non-compete might apply to them, they need to look at what the current wage threshold might be. I'll give an example. Oregon, close to California. Oregon's wage threshold law is RCW section 49.62.005 to .900. This went into effect January 1, 2020. This one bans non-competes for employees who make less than 100,000 annually. And then there's a separate section that says it bans non-competes for independent contractors unless their earnings from the parties seeking enforcement exceed a certain threshold, which is 250,000 annually. The law is not retroactive, and it does provide that these income figures are adjusted annually for inflation. So I'm reading you what it was in 2000. The wage threshold as of 2025 was 116,427. And in July of last year, Oregon enacted a new law, which we'll talk more about this trend in a minute, but it voids non-compete agreements between medical licensees unless certain ownership conditions are met, and also permits certain types of non-competes for up to 3 years under limited conditions. So again, it's just like a constant update in any state. But that gives you an idea of what a wage threshold looks like. So there are non-competes banned below a certain threshold, permitted above a certain threshold. Okay, next slide, please. Healthcare non-compete restrictions. 16 states currently, I'm sure there are more. Every month, I'm sure in the next 2 months, there are going to be a lot more that go into effect. A lot start in June and July. So there are 16 states. I won't read them. I have them listed on the slide. This is definitely the most successful category of legislation considered and passed in 2025. Some states, like Indiana, kind of surprisingly expanded their physician ban to cover all physicians. Other states have specific types of physicians that are covered and protected from non-competes. Some only dentists are protected. What is interesting is some of the rationale and the legislative history is pretty consistent across states. So, there's such an emphasis on patient continuity of care. If a doctor leaves and they're not able to compete, what might that do to patient continuity of care? What is that patient supposed to do? Just start over again? Find a new doctor? That could cause really serious health impacts. So that's one pretty consistent rationale. There's also concerns about rural and underserved access. If there's only a couple doctors that work at a particular physician's office and one of them leaves, that's a really significant decrease in the amount of doctors in that space if that doctor is not able to open their own practice, for example. There's also just a power imbalance in physician and many medical employer-employee relationships, and again, this public health interest in physician mobility. But it is certainly the case that healthcare is the frontier of non-compete reform nationally. A lot of legislatures are very, very focused on expansion of bans relating to healthcare employees. Okay, next slide, please. I know we're getting close. I'm cognizant of time. So there's a little bit of a counter trend, and I want to highlight this. So the Florida Choice Act, and there might be others, I'm aware of Florida's. This went into effect in July 2025. It actually strengthens non-competes for high wage earners. So it explicitly permits non-competes for up to 4 years. Most states limit it to 1 to 2. It creates a presumption of enforceability. Most states create a presumption of unenforceability. It shifts the burden to the employees who have to prove the unreasonableness of the non-compete, and it targets high-wage workers. It is the first that I'm aware of major state legislation that explicitly expands employer non-compete rights. It does demonstrate these divergent approaches across states. We have California on the one hand and Florida on the other. And it does create significant compliance challenges for multi-state employers. How to structure contractual relationships with your employees when you have such significant shifts from one state to the next. You have an employee in California where a non-compete is absolutely void, and then you have employees in Florida where they're presumptively enforceable for up to 4 years. That's the world we're operating in, though, within the absence of any sort of federal legislation or federal rule. Next slide, please. I want to just highlight a little bit of the 2026 pending legislation highlights to give you a sense of the scope here. So as you can see, there's, potential near total ban in New Jersey, potential total ban in Massachusetts, Virginia, potential healthcare specific ban, and then we have a couple of these wage threshold types banned for certain earners below a certain threshold, or void. Rhode Island is void unless they make more than a certain threshold. And then there's this Virginia proposal to make non-competes unenforceable if terminated without cause and not provided with severance. So there are a lot of different methods from state to state to continue to attempt to restrict non-competes. And this is, the volume is remarkable. There have been over 150 bills introduced in more than 35 states in the past 3 years alone. And so this is a space that just demands constant monitoring, especially if any of you do advise either employees or employers with multi-state, agreements or working in multiple states. And the choice of law piece is an enormously developing, like a rapidly developing area of law, especially with California's 2024 amendment. There are also a couple of states there where bans are going into effect. I just want to flag that Tennessee, a little bit surprisingly, does have a non-compete ban that will take effect this summer, banning non-competes for earners under 70,000. And oh, I already mentioned New Jersey is considering a near total ban. So there's just a lot of different approaches that we're seeing across the states, again, in the absence of any sort of federal framework. Okay, next slide, please. I know we got to wrap up. So there's some key themes. The state patchwork. This federal void has created this state patchwork nationwide. Healthcare is the leading frontier, and multi-state compliance is definitely going to be the primary challenge. There are these divergent approaches. I just want to highlight some states are moving towards total bans. Others are just focusing on raising the wage thresholds incrementally and maybe expanding from employees to independent contractors to volunteers. Florida is the only one that I'm aware of that is uniquely seeking to strengthen employer rights. And there is no convergence. There is no uniform national standard, and there is none in sight. Okay, next slide, please. Just to summarize the 5 areas that we touched on today. Number 1, California's prohibition is absolute, and it is continuing to expand. So we have not only that there's the non-compete ban, but it's recently been expanded to apply to financial mechanisms that effectively create a restraint on employee mobility in the form of traps. The second, we talked about DraftKings. It's not a death knell. Genuine California workers with an employment nexus in California probably remain protected by this 2024 amendment. Third, we talked about some of the new legislation that is going into effect in California this year. And there are these, again, the traps, and then also the healthcare one that we talked about. Fourth, the FTC rule is dead, and federal legislation and rulemaking is unlikely. So state law is the battleground. And fifth, we talked about just for potential implications for multi-state compliance, it will require a jurisdiction by jurisdiction analysis, and there is no chance of a one-size-fits-all approach without federal action. So with that, last slide, please. Thank you very much for attending this presentation and for your time and for your attention. I do see a couple questions here. I'm not sure. I might have to just, if any of you, unfortunately, I don't think I'm gonna be able to stay very long, but I think John and Jeffrey and Scott, my email's here, green@katzbanks.com. I'm very happy to talk with you all offline if you would like. I think scrolling through, some of these are a little bit more hypothetical questions that might take a little bit longer to get into, and I wish I had the time to get into them right now, I'm very, very happy to set up a call or to correspond over email with any of you that have questions. My email is green@katzbanks.com. I really enjoy talking about non-competes and thinking through these complicated issues. So please feel free to reach out with questions now or in the future. And thank you very much.
This concludes today's presentation. Thank you so much, Rachel, for an excellent presentation, and thank you so much to our audience. Have a great day, everybody.